Hello, this is social media attorney Mark Fiedleholtz, and welcome to my podcast on how the eroding qualified immunity defense impacts public employees using social media. I'm going to approach this podcast with a question and answer format to optimize the flow of information. Let's get started. Question number one: what is qualified immunity? Answer: qualified immunity is a legal doctrine in the United States federal law that shields government officials from being sued for discretionary actions performed within their official capacity unless their actors violated clearly established federal law or constitutional rights. And over the past number of years, great controversy has been created by the United States court rulings on what exactly constitutes clearly established law. The modern test for qualified immunity was established by the Supreme Court in its 1982 ruling in the case of Harlow v. Fitzgerald. Before this ruling, immunity was granted to government officials only if they believed in good faith that their actions had been legal. However, determining an official's state of mind proved to be very difficult and a subjective process, usually requiring a time consuming and costly jury trial. As a result of Harlow v. Fitzgerald, the granting of qualified immunity no longer hinges on the official's state of mind, but whether or not a reasonable person in the official's position would have known their actions were legally justified. In essence, this legal standard says for a reasonable person to truly know their actions were not justified, the plaintiff must prove that there is a legal precedent with the same precise facts in his or her case. So, the U.S. Supreme Court now has basically it's provided a barrier that you just can't overcome. It's just a very difficult hurdle. So, question number two: if qualified immunity is such a high bar, what are you worried about? Answer: the concern stems from recent United States Supreme Court decisions in Taylor versus Rojas. In this case, an inmate was forced to spend 6 days in appalling conditions, including a cell that was completely covered with feces. Since there was not an earlier case stating that condemned a prisoner, who was in a cell for 6 days with feces. Yes, it is unsanitary hell, but there was nothing in the precedents that said that it was unconstitutional. So the Fifth Circuit Court of Appeals predictably granted qualified immunity to the prison guards. But breaking with tradition regarding qualified immunity decisions, the Supreme Court reversed the Fifth Circuit Court of Appeals decision. The U.S. Supreme Court said that despite the lack of stating a case matching the exact circumstances at issue, the court held that any reasonable officer should have realized that Taylor's conditions of confinement offended the Constitution. In other words, the court was saying it was obvious. There's also another instructive case I want to discuss that reinforces the change in how the United States Supreme Court is viewing the legitimacy of qualified immunity defenses. Although this case doesn't specifically involve a qualified immunity defense, the same arguments were launched by the government that is used in most qualified immunity defenses. That's why I wanted to bring it out. And the name of the case here is Tanzan versus Tanvir. In this case, the Supreme Court granted a resounding victory to Mohammed Tanvir, who had previously been told by the government he could not sue FBI agents who retaliated against him for exercising his religion. The government stated, "We should be wary of damages against government officials because these awards could raise separation of power concerns." So that was their affirmative defense. But the U.S. Supreme Court ruled that there may be the policy reasons why Congress wants to shield government employees from personal liability, and Congress is free to do so. But there are no constitutional reasons why, or constitutional reasons rather, why the United States Supreme Court has to do it that way. All right, so finally, to show how the U.S. Supreme Court's old view of qualified immunity is eroding, I want to quickly discuss the case of McCoy versus Alamu. In the McCoy case, a Texas prisoner named Prince McCoy was pepper sprayed for no reason. The officer was agitated with another prisoner who had thrown water at him. But because this other prisoner was out of reach, the guard took it out on McCoy. He was an innocent inmate who had asthma. In a video taken after the incident, McCoy is shown pacing in his cell, unable to breathe. Eventually, McCoy sued, but the courts at the lower levels held that because there was not an earlier court case specifically stating that macing an innocent inmate is unlawful, the officer could not be held accountable for his actions. And as in the other cases, now the U.S. Supreme Court stepped in, but they vacated the judgment of the Fifth Circuit Court of Appeals. And basically, what they said here the case is remanded back to the Fifth Circuit Court of Appeals for further consideration in light of that Taylor versus Roja case that I mentioned earlier. And remember, in that case, it said that qualified immunity needs to be based on reasonability, not just factual distinctions. So these cases don't eviscerate qualified immunity, but they do represent the early stages of a seismic shift away from the U.S. Supreme Court and federal courts granting an automatic qualified immunity defense. And I thought it was very important for you to know this and see this legal trend. So basically, the Supreme Court's saying, instead of placing premium importance on the policy of protecting public officials from being distracted by lawsuits, the U.S. Supreme Court now is injecting the reasonability standard in their 1983 qualified immunity analysis. And that's a big deal, and you've got to know it, all right? So let's put it all together. Excuse me. Question number 3. What impact does the new U.S. Supreme Court view on qualified immunity have on social media in the public sector? All right, so we went through all this analysis and the change that the Supreme Court now has in terms of their determination of qualified immunity. But what does that have to do with social media and how the public sector or public employees use social media? And here's the answer. Let's be clear. The affirmative defense of qualified immunity never had a strong foothold anyway as an affirmative defense in social media related cases. The qualified immunity analysis in social media related cases is highly distinguishable from use of force cases that often involve instantaneous discretionary acts. So basically, you're comparing apples with oranges here. In social media related cases, the legal examination of the facts is applied to a long and deep history of clearly established U.S. Supreme Court and federal law that you cannot go on mass media platforms and defame, harass, threaten, and engage in other reputational harm that isn't covered by First Amendment speech protection. Additionally, many of the offensive comments are intentionally directed at people who are members of a federally protected class. So if you add the U.S. Supreme Court's new shift towards applying a reasonability standard in determining the validity of qualified immunity affirmative defenses, social media networks now have become a very risky area for public officials who think they can vent opinions and humor on social media with impunity. This especially applies to off-duty posts and tweets sent from a private social media account or personal device. Many public officials are unaware that in determining liability, courts focus on whether the work-related content was constitutionally protected, not whether the message was sent off-duty or on-duty or on a private social media account or on a personal device. So, again, combine this misperception with the loss of qualified immunity protection, and you have a whole different situation here. To me, it's like looking at the proverbial double-barreled legal gun of being sued in your official and individual capacity under Section 1983. Question number 4, which is our last question. Well, you said all this now, but do you have a cost-effective solution? Well, here's the answer. I do have an affordable solution. You need to immediately register all your employees for my low-cost social media liability online course and get them educated. If you don't make the comments in the first place, you don't have to worry about using shaky affirmative defenses like qualified immunity. You will stay far away from the courtroom. And my online and live courses dispel the myths surrounding social media opinions, humor, and privacy issues, which I can tell you now are the root of the problem to begin with. Also, I use over 30 years of my digital media law experience to teach you a new red flag warning system so employees identify and eliminate high liability speech. Look, you cannot wait for a social media mistake to ignite costly lawsuits that destroy the public trust and ruin careers. I mean, this is urgent. Courts consider every employee a broadcaster and publisher that can reach millions and create a permanent digital footprint. The days of having a sense of security because you gave your employees verbal warnings and handing out a boilerplate social media policy are over. Well, I hope I made a compelling argument to get your people registered right away. You will find my email and website and other contact information on the course flyer for you to sign up for my online course. I do want to thank you very much for your time, and that is the end of the podcast.